Hello, viewers. My name is Rajat Dosi. I am one of the partners at RSA Legal Solutions. And today we'll be discussing about the recent burning topic of classification, custom tariff classification, GST tariff classification of part and accessories of a vehicle. Now, to put it very bluntly, the issue of classification of parts and accessories of a vehicle in chapter 86 to 88 is as contentious, as complicated as the issue of taxability of software in India. In fact, both these issues have reached Supreme Court numerous times, but they are far from being settled. In case of this issue of classification of parts and accessories, even after 35 years of adoption of HSN based classification, we are yet to reach a firm conclusion as to how these parts and accessories of a vehicle are to be rightly classified in the tariff. Uh, to add fuel to this controversy, there are certain contradictory Supreme Court rulings which give one view and another Supreme Court ruling gives another view. In today's webinar, we'll be discussing about all the applicable legal provisions and also these contradictory Supreme Court ruling with a special emphasis on the recent Supreme Court ruling given in the case of Westinghouse, where a certain ruling has been given by the Honorable Supreme Court, which in our view respectfully is not the correct law of the land. And so therefore, towards the end, we will also share with our viewers a certain way forward or a roadmap, which in our view should be the correct approach to determining the correct classification of part and accessories of a vehicle. Before we begin with determining the correct classification, let us quickly have a look at the general rules of interpretation. These general rules of interpretation are nothing but statutory tools which have been provided in the customs tariff and also in the GST tariff with the intention of aiding and assisting the SSC in determining the correct custom tariff classification or the GST tariff classification. Now, why these rules are very important is because many a times we listen to our clients who usually say that as per them there are two correct custom tariff classification or GST tariff classification. Let me begin with saying that the tariff has been structured in such a manner that there can be only one correct tariff heading or there can be only one correct classification. It has been structured in such a manner there cannot be two correct classifications. You can have competing entries where your product gets classified otherwise by description in two competing entries, but out of those two competing entries you are required to come up with one correct custom tariff or GST tariff classification. First, for resolving issues when there are competing entries, these general rules of interpretation come in play and they come in handy, especially in such sort of situations. There are a total of 6 rules and 2 explanatory notes. However, for present discussion for today's topic, we'll be concentrating ourselves to only rule 1 to rule 3. The remaining rules you can have a look separately in case you want to have a deeper understanding as to how classification has to be done correctly in a customs or a GST tariff. The first rule is it states that classification has to be done as per the language or the text of heading. And it also states that you are also required to refer to and rely upon section note and chapter notes. For the reference of the viewers, the Indian tariff has a total of 21 chapters, 21 sections and 98 chapters. Every section, every chapter begins with certain notes, which again are towards aiding and assisting the SSC in determining the correct classification. So this rule is of very importance because it clearly lays down what are the things which you are required to consider while determining the correct customs or GST tariff classification. Second rule is to be applied in a situation where let's assume you are importing certain articles which otherwise are incomplete or unfinished but has the essential character of the complete or finished article. So to give you an example, say for instance you import a motor vehicle without the tires. Now without tires, the motor vehicle per se is incomplete or unfinished, but having said that, it has the essential character of a finished article. So as per this rule, even though it is not complete, it is not finished till, because it has the essential character of the finished or the complete article, it has to be classified as if you are importing the complete or the finished article into India. The same goes when you are importing anything in a unassembled or a disassembled form. Meaning, say for instance, you import something in CKD or SKD condition. In that situation, it will again be assumed that you are importing the finished or the complete article, and the classification has to be done accordingly. Now, this is very important, and a number of rulings by the Honorable Supreme Court have been given accepting and applying this rule itself, especially the recent, not the recent, but a landmark judgment given in the case of Sony India, wherein they have clearly held that whenever you are importing any article in CKD or SKD condition, then as per this rule, it will be assumed or it will be deemed as if you have imported the complete or the finished article. Now, for that, the only thing to be borne in mind is that when you are importing in CKD or SKD condition, all the goods should have been imported at the same time, maybe in one consignment or multiple consignment, but it should be at the same time. It should not so happen that some parts you are importing today, some parts after 10 days, remaining parts after 1 month. So if that is the situation, then this rule will not apply. This rule will apply only in a situation where you import all the parts combined together, maybe in one consignment or multiple consignment at or about the same time. So this again is very crucial and should be kept in mind whenever one is looking for a custom tariff or a GST tariff classification. The third rule is something which is very important, at least for the present discussion. It states that when you are classifying a particular item and they are competing entries, then in that situation, the entry which is specific should be preferred over the entry which is general. So just to give you an example, so say for instance, you were to classify curd and there were two competing entries. One was milk-based edible product and the second entry was all edible products. So in that situation, as per this rule, you will have to apply the entry which is specific, which will be milk-based edible product over the general entry, which is all edible product. So this is something which is very helpful and very essential because, like I said in the beginning, that you may have competing entries which may cover, both the entries may otherwise cover your goods as per description, but applying these general rules of interpretation, you are required to determine out of those two entries which is the correct entry. So this rule will help a lot of assessees in overcoming a lot of difficulties, especially when they are considering their situation and two competing entries are available before them. Then let us have a look at the relevant chapter headings, which are the bone of contention or which are creating a lot of problems as far as this topic of parts and accessories of vehicle is concerned. So these are few headings provided in section 17, which covers chapter 86 to 89. So these are some entries which covers part and accessories of a vehicle. Now, these entries usually have a higher rate of duty or taxes. So therefore, department wants to classify each and every part and accessory of a vehicle under these headings, even though that part or accessory may otherwise be covered by name in some other chapter. So to give you an example, say for instance, you are a tire manufacturer and you are supplying tire to a motor vehicle manufacturer. So in that situation, the question before you will be whether that tire will qualify as being covered under 8708 as part and accessory of a motor vehicle, because it indeed is a part of a motor vehicle, or it will merit classification under chapter 40 where tires are covered by name. There are a lot of other examples. Car carpets are there. So in case of a car carpet, again, the question will be whether your product will get covered under chapter heading 8708 as part and accessory of a motor vehicle, or under chapter 57, which covers car carpets by name under the category of textile carpets. So these are the issues. This is the very issue which has been troubling the assessees in a number of cases, and why it has even it has become more complicated over a period of time. We will see that once we have a look at the section notes. Now, there are a lot of section notes to section 17, but for today's discussion, we will be limiting ourselves to section note 2 and section note 3. And why they are important is, I have told you in the beginning itself, general rule 1 of general rules of interpretation clearly gives legal backing to section notes, and those are to be considered. You cannot take a position which is otherwise contrary to what has been indicated or said in the section notes. Section note 2 very clearly states that the expression part and accessories do not apply to the following articles, whether or not they are identifiable as for the goods of this section. So meaning thereby, if your product which you are intending to classify is covered in any of these 11 line items which have been provided, then in that case, it will not qualify and it will not be classified as part and accessory, even though it may otherwise be covered as a part and accessory. So to give you an example, say for instance, you are manufacturing these joints or washers. Then since joint and washers are covered in this section note 2, they will never be classified as part and accessory of a vehicle. They will always merit classification in the heading or the chapter which has been indicated in this. So therefore, the very first thing you need to do when you are classifying any item which otherwise qualifies as a part or an accessory of a vehicle is to see section note 2 and see whether or not your product is covered in any of these 11 line items. If it is so covered, then you will not ever merit classification under part and accessories of a vehicle. Now let us come to section note 3. Now this section note is the section note which is creating a lot of confusions. This is the section note which has been interpreted, or either I should say misinterpreted, by the Honorable Supreme Court in a number of cases, which is giving contradictory positions and which is making the issue even more complicated. It reads, first let me go through what is section note 3, and then I will come on to as to how it has been misinterpreted. It reads, references in chapter 86 to 88 to parts or accessories do not apply to part or accessories which are not suitable for use solely or principally with articles of those chapters. So if on a very casual reading, prima facie, it appears that this is laying down one of the conditions which is required to be satisfied if you want to classify any particular product as part and accessory of a vehicle. So the criteria they have specified is that the part or product should be such, the part or accessory should be such that it is capable of being used solely or principally as a part and accessory of a vehicle. So this is one of the qualifying criteria. Now, how it has been misinterpreted by the Honorable Supreme Court in certain cases is that they have read this qualifying condition as the only condition which is to be satisfied. So the reasoning given by them is that as per this section note, as long as you establish or satisfy the test of sole or principal use test, meaning thereby as long as you satisfy that the product what you are seeking to classify is capable of being used solely or principally with a vehicle, then it will merit classification under chapter 86 to 88, even though the product which you are otherwise classifying may be covered by name in some other chapter. So this section note 3 is what is complicating the problem even further by the fact that they have read one of the inclusion conditions to be the only conditions which is to be followed. Now, how it has created havoc, I will come on to that in a bit when we discuss the actual Supreme Court rulings. But bear this in mind that this is the section note 3 which is creating a lot of problems when we are seeking to classify parts and accessories. Now, also let us have a look at the HSN explanatory notes. For all our viewers who are not aware that India has adopted the HSN tariff-based classification, which was developed by the World Customs Organization. In fact, majority of nations, majority of countries of the world have adopted the tariff-based classification developed by the World Customs Organization, so that they have continuity, or so that they have a classification same at the 6-digit level across all the countries in the world. Now, the World Customs Organization has also given these HSN explanatory notes with a view that they can aid and assist the SSC in identifying the correct classification in the tariff. So these, even though may not have legal backing per se in India, but the courts, the Honorable Supreme Court in a number of cases have held that they have a very strong persuasive value. And in my experience, I have seldom seen a case where they have held a position or where they've taken a position contrary to the HSN explanatory notes. In fact, in all cases, they are followed to the term, and hardly you will see any cases where they go against. In fact, at least I have not seen any such cases. So therefore, when we are discussing section notes of section 17, it will be also be prudent to have a look at the HSN explanatory notes. Now, for section note 3, the HSN explanatory notes to section 17 lays down three conditions. They say that if you satisfy these three conditions, then the product which you seek to classify can be covered as part and accessory of a vehicle. Now, what are those three conditions? The first condition is that the product must not be excluded by the terms of note 2 of this section. Section note 2, we just saw that it enumerates 11 line items. So the first qualifying condition they say is that the product should not be covered by section note 2. Meaning thereby, again, if the product is covered by section note 2, then you will not merit classification as part and accessory of a vehicle as per section note 3 of section 17. The second condition is the same. They say that the product which you seek to classify under the category of parts and accessories must be suitable for use solely or principally with articles of chapter 86 to 88. So the same condition that they say that the product which you want to classify as part and accessory of a vehicle should be such that it is capable of being used solely or principally with a vehicle. Only and only then it will be considered to be a part and accessory of a vehicle and merit classification therein. The third and the most important condition which they laid down is, which in our view will resolve most of the issues, is they must not be specifically included elsewhere in the nomenclature. Meaning thereby, what they say is that if your product is otherwise covered specifically somewhere else, then it will not merit classification as part and accessory. Why I say this is very important is because this otherwise is not coming out from the terms or the language of section note 3. This condition they have incorporated as a part of HSN explanatory notes to section note 3. So this I think will resolve a lot of disputes. The only problem is that these HSN explanatory notes have not been considered by the Honorable Supreme Court in few conflicting judgments which I was referring to. If these HSN explanatory notes would have been considered by the Honorable Supreme Court, majority of disputes would have been resolved in a sensible manner. They have also given certain examples of products which are covered by name specifically in some other chapter, and therefore they will not merit classification as part and accessories of a vehicle. If we have a look at the list, in fact, the tires example we just mentioned at serial number 3, you'll see that they've mentioned specifically that when rubber tires are to be classified, they will merit classification under chapter 40 and will not be classified as part and accessory of a vehicle. Equally, they give at serial number 12 vehicle seats of heading 9401. So if you are manufacturing and supplying vehicle seats, then again it will merit classification under specific heading 9401 and it will not merit classification and as part and accessories of a vehicle. So these are examples which the HSN explanatory notes have given, which they say that if your product is any of these 11-12 line items, then it will be covered in the heading or the chapter which they have mentioned, because the product is covered otherwise there by name. It is more specifically covered over there, and therefore it will not merit classification as part and accessories of a vehicle, and therefore will not be classified in section note section 17, that is from chapter 86 to 88. Now let us come on to the judicial pronouncements we have been talking about. First, we will discuss the earlier judicial pronouncement, meaning the judgments given before the recent judgment of Westinghouse. So all in all, there were two types of judgments which were coming from the Honorable Supreme Court. One was these where the cases where they have applied sole or principal use test. One of the judgments was given in the case of GS Auto International. In this, the question before the Honorable Supreme Court was that the classification of nuts and bolts, which were tailor-made or specifically made for being used as a part of motor vehicle, was in question. the competing entries were chapter 73, where they are covered by name, or chapter 87, heading 8708 as part and accessory of a vehicle. Department wanted it to be classified under chapter 73, where they are covered by name. The SSE wanted it to be classified in heading 8708 as part and accessory of a vehicle. Now, in this case, the problem what happened is the Supreme Court considered section note 3 in isolation without referring to the HSN explanatory notes. So what they did is they simply looked at section note 3. They saw that section note 3 lays down the condition that the product should be such that it is capable of use solely or principally with a vehicle. And if it is the case, then it will merit classification as part and accessory of a vehicle, and it will not merit classification in any other chapter where it may otherwise be covered by name. So looking only and only at the sole or principal use test, they held in this case said that since the nuts and bolts are such that they are tailor-made to be used as a part of motor vehicle and cannot be put to use for any other purpose, then the goods will merit classification under chapter heading 8708 as part and accessory of a vehicle. So the thing is that in this case, the Supreme Court did not look at the HSN explanatory notes to section note 3. In fact, they were never argued before the Supreme Court for Supreme Court to have a look at the HSN explanatory notes. Because if HSN explanatory notes would have been looked at, then certainly the third condition, which is coming from the HSN explanatory notes, that the product should not be covered specifically somewhere else, would have been considered by the Supreme Court, and that would have tilted the judgment in the favor of the fact that since the nuts and bolts are covered specifically in heading 7318, the products merited classification under 7318, and they did not merit classification as part and accessories of a vehicle under heading 8708. The second is the judgment in the case of Uni Products India, where the issue before the Honorable Supreme Court was that how car carpets are to be classified. In this case, the SSE was supplying car carpets to a vehicle manufacturer. The question was whether they will merit classification under chapter 57, where they are covered by name under the category of textile carpets, or again they will be classified under the chapter heading 8708 as part and accessory of a vehicle. So in this case, the court went beyond section note 3, the language of section note 3, and had a look at the HSN explanatory notes, considered and applied the HSN explanatory notes, and clearly held that all the three conditions which have been specified in the HSN explanatory notes are to be applied. And if we apply all the three conditions, then as per condition 3, since this product, the car carpets, are covered somewhere else, specifically in chapter 57, the product will merit classification under chapter 57 correctly, and it will not merit classification under chapter heading 8708, which covers part and accessories. In our view, humbly, very respectfully, this is the correct judgment. This is the judgment which lays down the correct law, and the earlier judgment or the remaining judgments as given in the case of GS Auto, where they simply consider the language of section 03 and simply apply the sole or principal use test, is incorrect. Now, one thing to be borne in mind is that all these judgments are division bench judgment, comprising of two judicial members, two honorable judges of the Honorable Supreme Court. So they, in terms of its presidential value, it is at or above the same level. Both can be followed in subsequent judgments. Now, let us have a look at the recent judgment in the case of Westinghouse. In this, the issue, before I come on to the issue, let me tell you, this is not a division bench judgment. This is a judgment given by three honorable judges of the Honorable Supreme Court. So this will have a better precedential value as compared to the earlier rulings. So in this case, the issue for determination before the Honorable Supreme Court was that relays were being manufactured in such a manner that they could be put to use only as a part of railway signaling equipment. So the question before the Supreme Court was that how the relays are to be classified, whether they will merit classification under heading 8536, which covers relays by name, or they will merit classification under heading 8608 as parts of railway signaling equipment. Now, in this case also, what happened is Supreme Court had a look only at the language of Section Note 3, applied only the sole or principal use test as has been propounded in earlier judgment, and they followed the judgment given in the case of GS Auto. The HSN explanatory notes or the judgment given by the Honorable Supreme Court in the case of Uniproducts, which was a far recent judgment, was not put before the Honorable Supreme Court. So therefore, applying only the language of Section Note 3 and the sole or principal use test, they reached a conclusion that since these relays are capable of being used solely or principally as a part of railway signaling equipment, they correctly merited classification under heading 8608 as parts of railway signaling equipment, and they are not to be classified in heading 8536, which covers relay by name. So again, there is a judgment, a recent judgment, which of the Honorable Supreme Court of consisting of 3 judges, which follows GS Auto to hold that the only criteria is sole or principal user test. They completely ignored the HSN explanatory notes, or rather, I would say the criteria of specific over general test. Now, like I said, with utmost respect, in our view, this judgment of the Honorable Supreme Court does not lay down the correct position of law. There are three points which we think on which we believe that in the future it may be challenged either before the Supreme Court of the containing the same number of judges, or the question may be referred to a larger bench. The first point on which we think so is that they have not harmoniously interpreted all the provisions. In the sense, like I said, apart from the language of Section Note 3, they should have considered the HSN explanatory notes, which the courts have earlier very clearly held that they have a very strong persuasive value. At the same time, they also did not consider general rules of interpretation, General Rule 3, which clearly lays down that specific has to be preferred over the general entry. So this harmonious interpretation has not been done, and the conclusion is leading to an absurd situation. Why I say so is because, like in case of a tire, certainly if we apply only the sole or principal use test, will now merit classification under heading 8708 as part and accessory of a vehicle, even though it may be covered by name in chapter 40. So this certainly is leading to a very absurd situation. Tire in any case can never be a general tire. You cannot have a general tire. If tire is manufactured, it will always be used as or it is meant to be used as a part of a vehicle. So chapter 40 altogether would be rendered redundant by this interpretation or by this application of sole or principal use test. Now, therefore, there are a lot of judgments of the Honorable Supreme Court holding very clearly that when there are a lot of provisions, then all the provisions are to be interpreted harmoniously, and any interpretation will lead to absurdity or an absurd situation that should be avoided. In our humble submission, most respectfully, the Honorable Supreme Court has this judgment of the Honorable Supreme Court lacks on both these footings. They do not harmoniously interpret or take into account all the possible provisions, all the applicable provisions, and the judgment given by the Honorable Supreme Court leads to a very absurd situation. The second point in our view is that it may lead to chaos in the international trade. Why I say so is because, like I said, majority of countries of the world have adopted the WCO-based classification, the HSN-based classification. In all those countries, a lot of emphasis or a lot of legal backing is given to HSN explanatory notes. Now, if they were to classify it as per HSN explanatory notes, there may be a situation where when you are importing any part and accessory into India, the exporter in the country of export, while filing the shipping bill, may declare it to be in the heading or in the chapter where the product is otherwise covered by name, and at the time of import, you may be required to classify it under the category part and accessory of a vehicle. So the classification at the time of export and at the time of import may be different. And the same situation may arise even in case of exports from India. that when you are exporting from India, you put, let's assume you are exporting tire outside India. Then in that situation, when you are filing the shipping bill, the classification you will put will be 8708, and the importer in the country of import, as per HSN explanatory notes and as per the law over there, will be required to classify it under Chapter 40. So this certainly will lead to a lot of chaos in the international trade, and so therefore we humbly and respectfully say that the conclusion reached by the Honorable Supreme Court in this case is incorrect. Lastly, our submission, our view is that this judgment of the Honorable Supreme Court is per imperium in the sense that it does not consider and apply two very important factors. One is it does not take into account HSN explanatory notes to section note 3, which according to us lays down the correct view, which according to us lays down the three correct conditions which are to be satisfied, which would avoid all sorts of absurdity, which would harmoniously interpret the entire tariff. And at the same time, they also did not consider the earlier judgment given in the case of uni products, where the Honorable Supreme Court has in fact applied HSN explanatory notes and very clearly said that both the tests are to be applied, sole or principal use test, and also specific over general use test. Both the tests are to be harmoniously applied. If you apply only one single test of sole or principal use test, then it would lead to absurdity, chaos in the international trade, and therefore, in our view, most respectfully, this is not the correct conclusion which has been reached by the Honorable Supreme Court in this case. So therefore, in all likelihood, in future litigation before the Honorable Supreme Court, this ruling will either be discarded in the sense that the legal position will either be reversed, taking into account the HSN explanatory notes, the judgment given in the case of uni products, and also the general rules of interpretation, or the matter would at least be referred to a larger bench for a conclusion, a rightful conclusion in this regard. Towards the end, let me talk about the way forward. As per us, taking into account all the legal provisions, this is how we feel that a person should classify part and accessory of a vehicle. In essence, what we say is that you consider three questions before yourself when you are trying to classify any part and accessory. The first question is whether or not your product is covered, or whether or not your product is otherwise excluded in terms of section note 3. If the product is covered by section note 2, then it will not merit classification as part and accessories. It will be classified in the heading which is otherwise provided by section note 2. So the first question which you need to ask is my product covered by section note 2? If it is covered, then you will not merit classification as part and accessories. If it is not covered, then you move on to the second question. The second question is your part or product such that it is capable of being used solely or principally with a vehicle? If it does not so satisfy the test, again, it will not merit classification as part and accessory of a vehicle. It will be classified somewhere else. If otherwise it qualifies or it otherwise fulfills this criteria that the product is such that it is capable of use solely or principally with a vehicle, then you move on to the third and the most important question. Is your product covered specifically somewhere else or not? If it is so covered specifically somewhere else, then it will merit classification in the entry or the specific heading where it is so covered specifically. But if the answer to that question is no, that it is not covered specifically anywhere else, then and only then it will merit classification under the category parts and accessories in section 17. So these are three questions which, in our view, sums up the entire controversy, at the same time tries to resolve it by applying the HSN explanatory notes, which in our view lays down the correct situation, lays down the correct law, which will avoid any sort of absurdity, which will harmoniously interpret all the provisions, and which in our view is the correct law which should be applied in each and every given situation. Thank you for listening to us. If you have any queries or any concerns in this regard, do write to us. We have mentioned our email addresses, and we'll be more than happy and glad to give a response to any of your queries in this regard. Thank you.